All right, Ms. Davis.
For me, I would have Ms. Jamie Daniels testify. She would say that mom is in compliance with her services, although not fully demonstrating this safe and stable environment needed to return for the child to return home. The department still has concerns for this case regarding the nature of the allegations that brought the child into care, being the physical that on the pictures that were shown today, as well as what the mom testified to as well. Additional concerns is the way mom interacts with the child during the parent-child visits, displaying violence in front of the child and towards the child, just leads one to believe that she hasn't demonstrated a change in parenting styles. Additionally, Miss Daniels was not the one who located the Dream Center. That was the courtesy worker, Tara Grace. She worked with Jamie in finding one, and that although mom has worked all of her services, it has been at the exclusive help of the department to set up every single appointment, notify her of every appointment, visitation, where she needs to be, who she needs to go, makes the contacts for her, and says she.
I've been kicked off after I gave my last thing. I have been kicked off. I haven't heard any testimony.
Okay, so we are still on the department's witness being the caseworker, Ms. Daniels. So you want to go over that again, Ms. Davis?
I'll try as best as I can, Your Honor. That Dakota is in compliance with her services, yet the department does not believe she's fully demonstrated a safe and stable environment due to the issues that brought the child into care, as well as mom's behavior at the parent and child visits. She hasn't demonstrated those parenting skills that she iterated to the court earlier. Even now, she has missed multiple visits with counselors and never gave any indication to Jamie that she wasn't attending counseling. And Jamie was under the impression that she was still attending counseling. And so the department would be asking the court to deny the mom's motion for monitor return. And then I would have Miss Chelsea Blair, who is a HST worker out of Jasper County, testify. She was the one who supervised the 6-hour Christmas visit between Dakota and the child. She would testify that both her and Dakota were making jokes to encourage the child to eat the spaghetti, such as, let's play a game. Whoever picks up the most toys gets to eat the spaghetti. And in the cases that Carmen would win the game, she would still refuse to eat the spaghetti. So then they moved on to a different task and play a different game that didn't involve trying to get her to eat. Next, they went back inside the building and went into an art room that was open to the children, or a classroom, that had several different areas to play, such as a role play area, a play kitchen, a puppet station, a reading nook, and an art desk. The child was rapidly moving between each of the stations, and that frustrated Miss Oakes because she was trying to get her to engage in one station and keep her attention in one station, and would make comments such as, "I don't know why you're not tired," and she would continue to encourage her to take a nap or to eat the spaghetti about every 15 to 20 minutes. Then the child moved her interest over to the puppet station. And at that time was when mom pulled out the dog puppet and told Carmen to watch her. And she looked at the puppet. Puppy, do you want to eat your spaghetti? The puppy shook his head no. Then Miss Oakes proceeded to slap and punch the puppy several times in the face. She then turned to the child and said, "Now, do you want to eat your spaghetti?" Again, the child said no. So Miss Oakes said, "Let's try this again," and repeated the display of punching and slapping the puppy again. After that, Miss Oakes continued to display signs of frustration, such as loud sighs, eye rolling, and looking at the ceiling, making shrugging gestures, and just becoming overall frustrated with the situation. Eventually, she asked that a small cot be brought into the room to try to get the child to take a nap. Again, the child would only go and sit at the side of the bed for a few moments and then run away. At that time was when Miss Oakes made punching gestures towards Carmen while the child was only a few feet away. Miss Oakes then turned around and said that she was kidding, but frustrated because the child would not stay sitting. Miss Blair then told Miss Oakes that this was normal behavior for a 2-year-old, and she's never seen a 2-year-old sit for very long. Again, the punching gesture towards the child happened again about a half an hour later, and the child was not facing her the second time around. And so that would be my witness regarding that visit. And so based on that, the department would be again asking for the monitored return to be denied and for visitations to be ceased.
All right, thank you, Ms. Davis. And may I have that witness's name again?
Chelsea Blair.
All right, thank you. Okay, thank you. Mr. Crocker, would you have any witnesses? Did we lose Mr. Crocker? I see what I believe to be his iPhone.
No, Your Honor. I would have nothing to proffer. I apologize.
All right, thank you to Ms. Shipley.
Thank you, Judge. My first proffer would be my cross-examination of Ms. Daniels, the caseworker Jamie Daniels. I believe that Ms. Daniels' testimony would indicate that Ms. Oakes did not actively reach out for assistance in obtaining counseling recently, or make efforts herself to align that counseling. I believe that Ms. Daniels would also be able to say that Ms. Oakes has not had any articulation of future plans for herself or the child with any certainty outside of the Dream Center, and that Ms. Oakes is vulnerable for homelessness because of her circumstances now and has not made efforts to alleviate that, and that she is also vulnerable to manipulation because of the isolation. My next proffer would be Crystal Attaway, who is the daycare director where the child currently attends. And I believe Ms. Attaway's testimony would be that she met the child first within days of coming into care in May of 2021, that she witnessed the injuries, contusions, and bruises on the child early on, that they were alarming to her. She would also be able to offer that the child's behavior at the onset of this case, when she first met her in May of 2021, was reserved and hesitant, and that she has developed well, that she is well adjusted. She interacts with adults and peers in a much better way now than she did at the onset, and would also be able to attest that she is well cared for and well bonded with her foster mother. My last proffer would be, I'm sorry, two more, would be Charlene Coleman, who is the biological mother of Dakota Oaks. And I believe her testimony will be that she had concerns during the time Dakota lived with her regarding her parenting skills, her maturity, and her mental health concerns, and that she has no reason to believe that those have been adequately addressed, and that she is also concerned for both Dakota's care and Carmen's, if Carmen were in Dakota's care, because of the separation and alienation created by her current placement, by the current placement at the Dream Center, not the child's current placement. And that has further strained the family support that could be available. My last proffer would be my client, Amy White, who would testify as to the nature and significance of the injuries when the child was placed with her, and that it was more than childhood bruising, and it was alarming, and that it would have been alarming to anyone at that point. Additionally, that the mother has had an opportunity for months now to reach out and obtain information about the child, and she has done on a very limited basis, and that it has been communications indicating some immaturity about what to ask for and how to build upon those conversations and what information she would need to provide for the child. She would also be able to attest to the child's stability and security in the current home that she's in with Ms. White. And that would conclude my proffers.
All right, Ms. Shipley, thank you. Ms. Wright, any witnesses and or recommendation as the guardian ad litem?
I don't have any witnesses except I do agree with the proffers of Ms. Davis, of Jamie Daniels, and of Chelsea Blair. I also would proffer that Jamie Daniels would say that placing the child back with the mother is not a safe and stable environment. My concerns are, I don't think it's a safe and stable environment for many reasons that you've heard from Ms. Shipley and from Ms. Davis. Dakota Oaks is not attending counseling. She's doesn't have a plan, a real plan for college or work or taking care of Dakota. She has done nothing to try to find out about Carmen and what Carmen's needs and wants and likes and all of that sort of thing. Or she says, well, I don't know what to do when she's frustrated. I don't know. I don't think parenting classes have done her any good, and especially not anger management. I'm very, very concerned about this episode that happened on the Christmas visit. That is just shows violence over food and not wanting to eat a certain thing. I mean, this to me is just, the worst issue you could have over why you might want to use violence, although you should never use violence. But to get in a dispute with a child over food is just unfathomable to me. And I don't think that returning the child to Dakota Oaks would be putting the child in a safe and stable environment. I can't see it whatsoever. I know she's extremely bonded with the parents, and she should not be with Ms. White, and she should not be moved.
Right. Thank you, Ms. Wright. All right. Anything else from anyone else? The court does not believe that it needs closing arguments at this point. Beyond that, anything else from anyone else before I render? Based on the evidence, the best interest of the child and the safety of the child, we know that the safety of the children and the child in this case is our paramount concern. Best interest is always our primary consideration. The court at this time denies the mother's motion for monitored return, finding that that denial is in the best interest of the child. The court finds that the mother is just not ready to receive the child, that there is a lack of demonstrated parenting skills, that any move at this point would be detrimental to the child. I greatly commend the mother on her services, even her demonstration of late. I'm quite concerned about what happened over at the Christmas visit. And what compounds my concern is that this occurred not just after having worked services, but to use this technique, given the bruises, the contusions, and now I hear the permanent scarring of the child, just to me is highly disconcerting and alarming. It seems to me that ought to be basic and instinctive. So that is the ruling of the court. Again, the court finds it's in the child's best interest for the safety and protection of the child. As to the department's motion to cease visits, I'm neither granting that nor denying it. I'm taking that under advisement. So that's the ruling of the court, and I will sign an order to that effect. Now, here we are about 30 minutes from trial. Now, what I intend for us to do today is to commence the trial on the merits. I know we may have some discovery issues or issues with redacted case file, call narratives, or what have you. But I intend on commencing the trial on the merits and recessing until the 28th of February, and I'll be able to give you all an entire day at that time. So that will give everyone about a little over a month's time, and that's really the only significant time block that I have for you all, given the time I think it may take. So how are we so far? And my other question is, while we're here, do you all want to go ahead and commence on the merits now and not wait until 1:30? So let me go around. We'll start with you, Ms. McPherson.
Your Honor, I apologize, and I could be wrong. Multiple cases and multiple things. Did we already commence a trial on the merits on 11-1?
We did, Your Honor.
Yes, that's right. That's right. We did. Well, let me confirm 11-1 though. I think that's right. Any thoughts?
Judge, I would, I'm not going to claim to be an expert on this, but I think there may be some statutory issues with extending the 90 days that the court may know way more than me. But if proper, I would move for a mistrial on the trial that commenced in November and ask that we start trial today. And then that would absolutely clear up the 90 days from today being the trial date, since our dismissal date is already further out. It's not passed, if I'm correct.
Okay, let me hear that last maybe sentence or two.
Yes, sir. I believe the dismissal date, and I'm sure Ms. Davis has it handier than I do, is not until March.
Well, I believe that our dismissal date just happens to coincide with January the 30th. I mean, you know.
Okay. That's
So-
what I meant, that the dismissal date is in the future as we sit here today. And so if we commence trial before the dismissal date, the statute allows us 90 days to complete trial. If that's an absolute 90 days and there's not an opportunity to extend the 90 days, even though the court could extend the dismissal date, I think if we declare a mistrial on the November trial date and we commence trial today, then we do have 90 days from today to conclude the testimony and a ruling. It might make it cleaner.
Indeed, it might. Bear with me just a moment. In the interest of CO, for a continuation of final trial, and I'll call for the parents. I believe I see Ms. Oakes, Dakota Oakes, if you can simply unmute and announce your appearance.
Here.
All right, thank you very much. And what about the father, Jadrick Alexander? All right, I don't see a phone number I don't recognize. I do not see the name. No one is currently in the waiting room. If anyone else sees or knows otherwise, please let me know at this time. Jadrick Alexander. All right, and Mr. Crocker, you are here for him. Final trial. All right, is the department ready, Ms. Davis?
Yes, Your Honor.
All right, thank you. And is the mother ready? Ms. McPherson, are you ready?
Yes, Your Honor.
Right, thank you. And Mr. Crocker?
Ready, Your Honor.
Okay, thank you. And Ms. Shipley?
Yes, Your Honor, we're present and ready, and Miss White's with me.
Perfect. All right, very good. So the court will mark Ms. White present, of course. And Ms. Wright, are you ready?
Yes, Your Honor, I'm ready.
All right, thank you very much. Okay, any request for opening statements? I believe those were deferred when we commenced on the merits. Hearing no request, Ms. Davis, you may call your first.
I will call Miss Jamie Daniels.
Okay, Ms. Daniels.
Where's the child currently placed?
She is in a foster home in Jefferson County.
And how's she doing in that placement?
She's doing really great. She's growing. She's very smart. She's learning. She's meeting her milestones. She's up to date medically and dentally.
Are there any issues or concerns at this time with the current placement?
No.
Do you believe it's in her best interest to remain there at this time?
Yes, I do.
What are the department's goals for this case?
Unrelated adoption with concurrent unrelated conservatorship.
And is that with the current placement?
Yes.
And have you had a conversation with them about being a permanent placement for this child if the need arises?
Yes, I have. And they are willing to adopt.
Okay. When did the department take temporary managing conservatorship of the child in this case?
It was around May 14th of 2021.
Okay. And how old was the child at that time?
She was around 1.
Okay. And when was she placed with this foster placement?
Around the time that she was removed. She's been in this placement the entire time.
Okay. Have family plans of service been created for the parents in this case?
Yes, they have.
And can you tell the court the dates of the status hearing where they were made orders of the court?
Status hearing was July 6th, 2021.
Okay. And at this time, who is the alleged father in this case?
Jadrick Alexander.
And was it required of him to submit to DNA testing?
Yes, ma'am. I believe we asked him to go 3 separate times and set that appointment up, and he did not submit.
Okay. Has anyone else been alleged as the father for the child in this case?
No.
And was a paternity registry search completed?
Yes.
And was there any intent to claim paternity on that certificate?
No.
And has that been filed with the court?
Yes, it has.
Okay. Was a service plan still created for dad and made a court order on July of 21?
Yes.
And what were the requirements on his plan?
We provide safe and stable housing, adhere to general rules, maintain contact with the department, obtain and maintain legal and gainful employment, provide proof of employment, attend all current and pending criminal charges, and submit to drug screens, and will attend and actively participate in a parenting class and provide certification.
At this time, would you say that he's in compliance or not in compliance with his plan?
He's not in compliance. He hasn't completed any services.
Does he maintain contact with you or the courtesy worker in this case?
No, he does not.
Does he have safe and stable housing?
It's unknown, as the address he provided me and his courtesy worker cannot be located. She's been out and she's reported to me that the address is cannot be found. I spoke with him on January 30th of 2023. Very briefly, he answered the phone. I let him know that we needed to discuss some things, as I had not talked to him in months, maybe since April. And he told me he didn't have time to speak to me and he would call back at a later time. He never called back, and I've tried to call him and he's never answered the phone.
Is this the same number that you've been able to reach him at sporadically throughout this case?
Yes, it's the same number.
Has he ever provided you with any other phone number or way to get a hold of him?
I had a different phone number in the very beginning of the case. And then around April, he provided this other phone number to me, but it's the same phone number. that I've
Okay.
had since probably April 2022.
And what efforts do you make monthly to try to make contact with him?
We call him, we try to send him a text, and the courtesy worker goes out to his home.
Okay. And is that like a group text message between you, the courtesy worker, and him so that y'all are all aware of the communication?
No, ma'am, it's not a group text, but I do communicate with Miss Patterson and
Okay.
just ask her if she's heard from him, if she's been able to locate him. At one point, I know she tried to locate where he was working and go there. As he gave us the address and he stated he worked at Whataburger and he walked to work, but there was no Whataburger within miles of the residence, the road that he gave us. The house cannot be located.
Are you requesting for him to drug screen for you?
We did ask him to go drug screen. I believe it was court ordered. And I did speak to him about that and let him know he needed to go. He did not go. I called him to find out why he didn't go. And he said, well, he needed transportation. So we tried to arrange transportation for him, but he would not answer the phone after that. And we could not find the residence that he was living at to provide that transportation for him.
Okay. So it seems like every time he might be willing to talk to you, but once something's required of him, he kind of goes silent, right?
Right.
Okay. Was there a visitation in place for him with the child?
There was. He was getting 1 hour every other week. We were transporting CO to Houston to see him. He did one visit. Then the following, not the following week, but the following visit, he confirmed his visit. We took CO down there and he canceled the visit when we got to the office with her. And that was the last time he confirmed a visit, wanted a visit, or anything to do with CO.
Do you recall when that visit occurred?
That would have been, okay, I don't know the exact date, but I know April was the last visit he actually attended in April. So it would have been just following April.
April of 22?
Yes.
And has he been afforded those visits biweekly since then?
Yes, he could have done his visits. He just never confirmed, didn't answer the phone any longer. He would have had at least 1 hour biweekly this entire time.
Okay. And regarding mom, has she completed and filed an affidavit of voluntary relinquishment?
Yes, ma'am.
And are we asking the court to terminate her parental rights based on that affidavit?
Yes.
Are you asking the court to terminate the parental rights of both Jadrick Alexander and Dakota Oaks today?
Yes, ma'am.
And do you believe that's in the best interest of the child so that she can maintain stability and safety and have permanency in her life?
Yes, I do.
Is there anything further you'd like to inform the court of today?
No, ma'am.
I'll pass the witness.
All right, thank you. Ms. Daniels, do you know when the certificate of paternity registry search results was filed?
You give me 1 second, Your Honor. I can tell you January 11th, 2022.
All right, thank you. Any objections to the court taking judicial notice of the certificate of paternity registry search?
No, Your Honor.
No objection.
All right, the court will hereby take judicial notice and admit the certificate of paternity registry search results filed on January the 11th, 2022. Thank you. Ms. McPherson?
Yes, Miss Daniels. Was the affidavit of voluntary relinquishment executed and notarized on February 13th of 23 and e-filed with the court on February 17th of 2023?
Yes, ma'am, that's correct.
Okay. And are you asking this court to take judicial notice of that affidavit that's been e-filed with the court?
Yes, ma'am.
Do you believe that she did that voluntarily?
Yes,
And there was no coercion or promises made, correct?
that's correct.
All right, thank you. I'll pass you as a witness.
All right, thank you. Any objections to my taking judicial notice of mom's relinquishment? And
No,
admit,
Your Honor.
No objection.
No objection.
all right, thank you. The court does take judicial notice of the mother's affidavit of voluntary relinquishment filed on February the 17th, 2023. So the court will note it and admit it. All right, did you pass the witness, Ms. McPherson?
I did, Your Honor.
All right, thank you. Mr. Crocker?
Ma'am, the monthly contact letters that you sent to the father, did they get returned to the department?
I'm unaware if they were returned or not, Mr. Crocker.
But those would have been sent to the address that the courtesy worker said was non-existent, correct?
Correct.
Okay. Early on in this case, Mr. Alexander's family expressed an interest in this child. Is that correct?
I was not the worker in the beginning of this case.
Okay. Is there anything in the notes that would indicate that his aunt was initially interested in this child?
It is my understanding that some family on Jadrick's side was looked at for potential placement. They were not approved as placement. They didn't pass I'm sorry. Anyway, they did a home study is what I'm trying to say. They didn't pass a home study. And then the other individual that was on Jadrick's side of the family was did not remain in contact with the department.
Okay. Would you say that your January 30th contact with Mr. Alexander, he essentially expressed no interest?
I would agree with that. I called, he answered, asked if this was Mr. Alexander. He said no. And I said, is this Jadrick? And he said, yes, this is him. Who is this? And I told him who it was. And I said, we have a lot we need to discuss, Mr. Alexander. Do you have a few minutes? So he said, no, I don't. He said, I'll call you back in 5 minutes. And I said, okay, call me right back. He did not. I attempted to call him back a couple of times that evening, within an hour. And then again later that evening, he did not answer the phone. He's not answered any text messages. And I've also tried to call him today. He did not answer again today. I left him a message. He didn't ask anything about CO. He didn't ask anything. I wanted to discuss what's going on with his case with him, but he didn't want to discuss it, I think, because he never called back and never answered.
In the text that you said, would it indicate that he received those?
It doesn't have read on there. It's not set up to display whether the text was actually read or not, but I did text him at the phone number he answered on and identified himself.
Okay. All right. Thank you, ma'am. I'll pass the witness.
All right, thank you. Ms. Shipley?
Yes, Your Honor. You moved. Miss Daniels, did the mother ever indicate there was a biological father other than this man?
She said there was not. He was the only potential father.
Okay. Has she had ample opportunity to name someone else if there had been?
Yes, ma'am. I asked her if she was sure, and she said she was sure.
Okay. And when you contacted the alleged father, did he ever acknowledge or deny that he was the father?
He never stated yes or no. We did the one visit. He did show up for that visit. He played with her. He never stated, I am the father, I am not the father at this visit, but it's insinuated that he come to the visit that he thought himself potentially the father.
Okay. And have you previously made him aware of the court order for a DNA test?
Yes, ma'am.
That's all I have. Pass the witness.
All right, thank you, Ms. Wright.
I have no questions, Your Honor.
Okay, thank you. Back to you, Ms. Davis.
I have no further questions and no further witnesses, Your Honor.
All right, thank you. Ms. McPherson, you may call your first.
Your Honor, I know that my client is here. She, I don't know if she wants to participate or not. I will call her. Miss Dakota Oaks.
Yes, ma'am.
I told you that, because you signed your relinquishment that, if you didn't want to participate, but you're here. So I will call you if you want to say anything on the record. And you were sworn in, correct?
Yes, ma'am, I was.
Okay. So, you signed the voluntary relinquishment on February 13th, correct?
Yes, ma'am, I did.
And we went over it in person with you, with all the rights and duties and everything else that you were voluntarily relinquishing as to CO, correct?
Yes, ma'am.
Do you feel that although you would have loved to have her home, do you believe that this is in her best interest so that she can remain in the foster family that she's currently in?
Yes, ma'am.
I know it's hard and I'm sorry, I don't mean to make you cry.
No, it's okay. It's just a struggle.
Okay. And no one promised you anything, threatened you or anything else. Is that correct?
That's correct.
Okay. Anything else? Well, I just, it's a very hard decision, Dakota, for any, and it sometimes can be the most unselfish thing a parent can do. Okay, and I want you to know that. And you're making me cry. So I'm gonna pass you as a witness, okay?
All right, thank you. Any questions from anyone for Ms. Oaks?
No questions, Your Honor.
No questions.
Okay. All right, thank you, ma'am. Any other witnesses, Ms. McPherson?
No, Your Honor.
Okay. All right, thank you. Any witnesses, Mr. Crocker?
No, Your Honor, no witness.
Thank you. Ms. Shipley, you may call your first.
I would call Amy White.
All
I'm
right.
going to turn the camera here and see if I can do this.
And Ms. White, were you sworn in?
I was.
Perfect. Thank you. You may proceed.
Would you state your name for the record? Amy White. And has the child lived in your home for a long time now? Correct, since she's come into care. And I want to thank you for being a consistent placement. Have you had an opportunity to interact or meet Dakota? I have, yes. And do you have any ill will or negative thoughts about her going forward? No. You wish her well? Yes. And you hope that she does great things in her life? Yes, for sure. Okay. And are you thankful that she brought CO into the world? Definitely, yes. And do you believe that at this time it is best for CO to remain in your care? I do. Have you began a program for this child to meet her academic and educational needs? Yes. And is she very smart? Extremely smart. And do you believe that continuing in your care that will be continued? Yes. Do you believe that you have put into place a system to meet her medical and physical needs? Yes. And do you intend to continue that? Yes. Do you believe that termination of both parental rights is necessary for you to meet this child's needs through adoption?
Yes.
And as it pertains to the alleged father, do you have any relationship with him?
No.
And have you ever had any interaction or relationship at all with him?
No.
And you don't know one way or the other anything about his parental abilities?
No.
Would you agree with me that since she's been in your home, since she came into care, that he has failed to meet the needs of the child?
Yes.
Has he ever provided child support for her?
No.
Has he ever provided any items of support for her?
No.
And do you believe it's best that that man's parental rights be terminated?
Yes.
I pass this witness.
Okay, thank you, Ms. Wright.
I have no questions of this witness, Your Honor.
Okay.
Very well. And I wish them the best of luck, and I wish Dakota the best of luck. But I think this is the very best thing for this child.
Okay, thank you. Thank you, Ms. Wright. Any request for any closing statements, arguments?
Your Honor, I would just have a simple request that termination be based solely on the, I can't help it, I'm crying, voluntary relinquishment.
All right, any response to Ms. McPherson's request? Right. At this time, the court does find that it does have jurisdiction over this case, the child, the parties, that they are properly before the court are the necessary parties. The court does find that the department has made reasonable efforts to reunify this family. The court finds that the father of the child is unknown. Further, that the mother has executed and filed with the court an affidavit of voluntary relinquishment that the court finds to be voluntary and in proper form and properly witnessed and executed. Ms. Oakes, I wish you the absolute very best going forward. It seems to me that what you have done shows just an uber supreme maternal love under the circumstances. And so I wish you the very, very best going forward. Based on the clear and convincing evidence, the court does find by that standard that the termination of the rights of both parents in this case, the mother Dakota Oakes and the alleged father Jadrick Alexander, or any unknown father, is in the best interest of the child, the subject of the suit, whose initials are CO. As to the grounds for the mother, the court terminates her parental rights pursuant to Texas Family Code 161.001 B1K and B2, best interest, both by clear and convincing evidence. As to the alleged father, Jadrick Alexander, and any unknown father, the court terminates parental rights pursuant to Texas Family Code 161.002 little b number 2 and capital B and little e. The department is named the Ms. Davis and Ms. Shipley. Is the department taking PMC today?
Yes, Your Honor.
We're in agreement with that.
Right, thank you. So the department is hereby named permanent managing conservator of the child. The court sets the first permanency review after final order for May the 16th at 9. The court approves of the placement, the department's primary permanency goal, and orders no move of the child, barring a bona fide emergency, without first a hearing and further order of the court. Once time has lapsed for any appeals, all of the court appointments, with the exception of Ms. Wright, will be discharged with the court's gratitude and appreciation. Mom, please take care.
May I say something real quick?
I'm going to let you.
I want to thank all y'all for at least giving me a chance to fight for her. And I want to personally thank Miss White for taking such good care of my daughter and y'all putting her in a place that loves and supports her. Because I have bad experience with foster homes. And so I just want to thank the department for putting her in a good one and letting her meet her milestones. And I want to thank all of y'all for reasoning with me, as I didn't have all the resources, and letting me get to see Carmen and CO for transporting her and helping me with my service plans. I probably wouldn't have been able to try to fight for her without any of y'all. So from the deepest of my hearts, I thank all of y'all for all that y'all done, and especially you, Miss White. Especially you. And you have the uttermost respect from me for taking care of her and loving her like if she was your own. And sorry. And that's all I have to say.
Okay, Dakota, thank you. And I certainly, and I think most of us do, join in and share your gratitude and appreciation and respect for Ms. White. It might be a little too much to hope for, but I would hope that CO's experience will some way help soothe, if not heal, your experience growing up in foster care. It has been a joy to know you over these almost 650 days, Ms. Oakes. I believe that you are in as good of a place as you have been in that amount of time. So please do whatever it takes to stay on this course and this present trajectory of your life, because there is nothing that indicates to me that you do not have a bright future ahead of you. So do whatever it takes to stay the course, and love yourself enough to be protective of yourself, okay, going forward, because you deserve that, and you're an exceptional person. Thank you.
Yeah, you can. Judge, go ahead.
I was just going to say, thank you, Miss Oakes, for, bringing into the world such a beautiful and wonderful little girl. And thank you for those kind words you just provided. And I can promise you that she's going to be very well taken care of and provided the best life with so many opportunities. So thank you for everything.
Thank you, Ms. White. Thank you. All right. The best to you all. I will sign these orders as soon as I see them, and we will see you all back department on May the 16th at 9 o'clock. So thank you all, and you are excused. Okay.